Court calls the case of the people versus Samuel People.
Caitlin Kirby on behalf of the people.
Right out of the gate, this hearing already feels chaotic. And if you've watched enough virtual courtroom proceedings, you know that usually means somebody's communication has completely broken down before the judge even logs in. Judge Simpson is stepping into what should have been a routine procedural moment, but instead the court is immediately dealing with confusion over contact attempts, missing communication, and a defendant who apparently hasn't been properly reached by his own legal team. That is never where you want to start a criminal case. And pay attention to the energy here, because this is the kind of hearing where small procedural problems can suddenly snowball into massive legal consequences. Judges care about cooperation, responsiveness, and credibility. If the court thinks you're dodging communication, even accidentally, patience disappears fast. What also makes this interesting is that a plea discussion is already being mentioned almost immediately. That tells you there may already be negotiations happening behind the scenes, and when that happens, every missed phone call suddenly matters 10 times more. One misunderstanding can delay everything. And trust me, the moment family members start jumping into the conversation directly with the judge, things can get very unpredictable very quickly.
Assistant Public Defender Qasim Lubesi on behalf of Samuel Peoples, Your Honor. Mr. Peoples, could you please unmute and state your full name?
Hi, Samuel Peoples.
Thank you. What are we doing?
Yes, similarly, Your Honor, we would request a short adjournment. I was not able to get in contact with Mr. Peoples. I need him to call our office and update his contact information. Previously, I believe a hideout plea was discussed, so I do need some time to discuss that with him and see if that's...
May 3rd, 2023, 9 a.m. Mr. Peoples, do you have the public defender's office number?
You've called it. Tell them you've already called it, Sam.
No, I don't think I have.
So I'm his mom. Currently,
Yes.
Sam is in a rehab because hit by a car on a skateboard and was in the ICU for 3 weeks. I've spoken to the defender's office. Samuel has called and left voicemails. And I have also spoken to the prosecutor side, and there's several notes within the chart from Christine Endler.
You have the phone number, though.
That, yes, we have it. and you
Okay,
have it. You've
okay,
called
ma'am,
several times.
ma'am. Here's what we're gonna do. Call the public defender's office, make sure they have the correct number. And if you don't want to do it, ma'am, I'll talk directly to him. So don't shake your head when I'm talking to you.
He has
Call
called
them. I'll wait till you're done.
Okay, I have called directly. I have been present when my son called directly. I have my son's phone. He has text directly, and no one has responded to him.
I wanted to ask to verify the phone number, but I called the phone number repeatedly yesterday, the phone number that our office has on file, and I didn't receive any answer.
Right, he is in a rehab right now. This entire case, he went through probation
Can
already
I just
for 6
get
months.
you to do one thing for me, ma'am?
This is the exact moment where Judge Simpson starts trying to regain control of the courtroom, because you can already hear the hearing drifting away from procedure and turning into an emotional family argument. And honestly, you can understand both sides here. The mother clearly feels ignored and frustrated, especially after describing serious medical issues involving her son being hit by a car and ending up in the ICU. But from the judge's perspective, there's a legal structure that has to be followed. Notice how the judge keeps redirecting everything back to one simple instruction: contact the public defender's office and verify the information. That may sound repetitive to viewers, but legally it's important because the court needs one clean communication channel. Without that, cases stall, hearings get adjourned, and plea negotiations become impossible to manage. Then comes the moment that completely changes the tone. The mother starts pushing about phone numbers publicly while the hearing is literally streaming online. Judge Simpson immediately shuts that down with the "We're on YouTube" mom line, and honestly, that's one of the most unintentionally hilarious but realistic courtroom moments you'll ever hear. Have you noticed how quickly virtual hearings can spiral once multiple people start talking over each other? because this judge definitely noticed it too.
I realize that's your son. He has attorneys. So if I can just get you to do one thing, and that is just please call the public defender's office, make sure that the information that they have to contact you and your son is correct so that they can discuss it. My understanding is there may be a HIDTA plea on the table, which is greatly beneficial to your son. So you sitting here talking to me isn't going to do you much good until we can get this resolved.
Well, which number do you have for Samuel? Why don't you ask Sam what number you have?
No, we're not going to put the number out. We're
Okay.
on YouTube, ma'am. I don't want it broadcast to the world unless you want everybody calling.
Well,
That's why
honestly,
we do it this way.
Sam has the defender's office number and he's called multiple times.
Okay.
I'm just,
Ma'am, ma'am. I don't know you know what? Here's what we're going to do. Mr. Bopesi, guess what? You're the lucky one today. You get a breakout room because I'm done with this one. I'm going to put you into a breakout room. That way you can communicate whatever you need to communicate without mom putting all his business out in the street.
Thank you, Your Honor. I appreciate
Put him
it.
into a breakout room. May 3rd.
operating.
May 3rd.
Sam Bernstein for Mr. Johnson, Your Honor. Here.
Yeah.
What's going on, man?
Not much. You look good in orange.
No,
All right.
Oh, yeah. So we're asking the court to please set this for a preliminary exam, Your Honor.
We
Yeah.
have all discovery shared with the exception of the 911 call that was requested earlier this week. It should be over to Mr. Bernstein by the latest on Monday. My expectation would be more likely that it gets to him tomorrow.
Now the entire atmosphere changes. The first case was messy and emotional, but this case immediately sounds more serious the second the bond discussion begins. Anytime prosecutors start talking about cash bond amounts, bench warrants, custody history, and repeated violations, the court's focus shifts from simple scheduling to public safety and compliance. And listen carefully to how the prosecutor builds this argument step by step. This is not random storytelling. Prosecutors intentionally create timelines to show patterns. First, the defendant was arrested, then released, then failed to appear, then picked up again, then allegedly continued problematic behavior while in custody. Every single piece is being layered together to argue one thing. This defendant cannot be trusted to follow court conditions voluntarily. The most damaging part is not even the missed appearance. It's the allegation of over 100 phone calls to the victim's number. Once alleged no-contact violations enter the conversation, judges become extremely cautious because now the court has to consider intimidation concerns, witness pressure concerns, and bond compliance concerns all at once. And what makes this hearing fascinating is that the defense is about to counter with one of the most unexpected explanations you'll hear in a courtroom all week.
When the court, well, I would like to address bond.
Why don't you go ahead and address bond?
So I understand in this case, bond is currently set at 10,000, cash or surety with no 10% privilege. We did request 150,000 on this case originally. I understand he has his bond currently denied out of the circuit court, and multiple holds in this case. I am actually requesting that bond be raised today, as well as his phone privileges be revoked. I am concerned because the way that I see this playing out is that he was taken into custody for this event that occurred back on May 2nd. After he was taken into custody, he was in custody for a period of time, then was released. Before he was released, we had stipulated to adjourn this case to May 23rd. On that day, he failed to appear and a bench warrant was issued. He was then picked up and arraigned on the bench warrant on July 9th and given the 10,000 cash surety without 10% privilege. In the time that he was in custody before he was released and since he has been picked up, he has called the victim 105 times at her personal number, as well as called the family line 110 times. where the victim answers that phone among other people a period or a number of times. I don't know what contact he had with the victim while he was out of custody, but given his failure to appear previously, as well as the extensive violations in the form of calling the victim, I would be asking for the increase in his vulnerability to be revoked today.
This hearing just took a hard left turn into pure courtroom reality television because the defendant's explanation is unfolding in real time and Judge Simpson is trying to figure out whether this is an actual misunderstanding or an elaborate excuse. The prosecution is saying the victim's number was repeatedly contacted. The defendant is saying, no, that was my other girlfriend. And somehow the conversation only gets wilder from there. What's important legally is that the judge does not actually need to determine absolute guilt on the spot to react to possible bond violations. Judges operate cautiously during pretrial conditions. If there's enough concern that a no-contact condition may have been violated, restrictions can tighten immediately while the court investigates further. That's why these hearings matter so much. But then the defendant starts volunteering extra information, multiple girlfriends, shared relationships, pregnancies, overlapping connections, and every extra detail creates more confusion instead of helping clarify the issue. Sometimes defendants think giving more explanation helps credibility, but in court, too much talking can absolutely backfire. And you can hear Judge Simpson letting him speak, while also mentally calculating whether any of this actually resolves the core problem. Why the same phone number keeps appearing in the records. At this point, would you believe this explanation if you were the judge?
Your Honor, as far as the phone calls go, Mr. Johnson states adamantly that he's not called Miss Vesey. He says that it was another woman that he's been calling, and that he has not had any contact with Miss Vesey since he's been in jail by phone, Your Honor.
I apologize. It is the victim's phone number because the victim has called our office and provided that phone number that he has called 105 times as her point of contact to our office.
That's my phone. That's not her number. I call my other girlfriend. That's my phone.
He says he's calling his other girlfriend, Your Honor. I'm sure Ms. Barroso will get me the phone calls. I'll listen to him ASAP. If there's something different, then I'll know within like a day or two. I know what Miss Vesey sounds like on the phone, so I'll be able to tell whether it's her or not.
Your Honor, y'all say something, Your Honor.
Usually doesn't work well, but go ahead.
I know. Yeah, the number that I've been calling, I got two girlfriends. One is Mrs. Vesey and the other is Jaleesa. I called Jaleesa off of my phone number. It's an 858 number. It's registered to my name. It's in my name. Miss Vesey's phone number, I do not call at all. And when I was coming out here, I seen Miss Vesey in the back. Miss Vesey can attest to you. I ain't called her or I haven't called her. I know the contact order, so I know I ain't supposed to have no contact with Mrs. Vesey at all. So I called my other girlfriend, which is Jaleesa. And then once you hear the phone, once you get the phone records, the 100 and whatever times, I'm not too for sure how many times I called her, but once you get the phone records and you hear the phone records, you'll clearly hear that it's not Mrs. Vesey, it's Miss Jaleesa that I am talking to on the phone. Now, if you can hear the records as well, you hear me on that phone call, those same phone calls, telling Jaleesa that I cannot have no contact with Mrs. Vesey.
This is one of those courtroom moments where the defense strategy becomes painfully obvious. Create enough uncertainty that the judge hesitates before imposing harsher restrictions. And to be fair, the defense attorney does make a legally important point afterward. Nobody in court has actually discussed the content of the calls yet. They're arguing over phone numbers, not verified conversations. But Judge Simpson's reaction tells you exactly how judges think during bond compliance hearings. He basically says, I don't know what's happening, but I know the number matches. That's the key. Judges are not required to wait for a perfect factual breakdown before acting cautiously. If there's enough smoke around a possible violation, temporary restrictions become very likely. And honestly, the defendant hurts himself a little by continuing to volunteer personal details that don't directly solve the issue. Once the courtroom starts discussing relationship dynamics instead of legal compliance, you can almost feel the judge losing patience. Then comes the big consequence: revocation of phone privileges. That's a serious restriction inside custody because communication access matters enormously for inmates trying to stay connected with family and coordinate legal defense matters. You can hear the defendant instantly realizing the broader impact too. He's suddenly worried about losing contact with everybody, not just one number.
And for her, I can't have no third party contact as well with Mrs. VC. So once y'all able to get the contact or the phone records or whatever to my attorney in this court, y'all can listen to him and make the determination. But I don't call Mrs. VC, and Mrs. VC is in the.
All right, well, let me ask you this then, since you decided to volunteer this. As between your two girlfriends, would there be any reason they would share a number?
No, there's no reason that they would share. No.
So why would the prosecutor indicate that the number that the victim in this case gives them to contact her is the same number that you're calling from the jail?
Now that I don't know. I don't know why she would indicate that or what even would give the indications that I'm talking to Mrs. VC, but Mrs. VC is right there.
Okay, do these two women know each other?
Yeah, they know each other for sure. I mean, like I said, we was in a three-way relationship. So like they know each other for sure.
Okay.
And Mrs. VC right there, if you would like to call her up here.
No.
Or she can attest it. I can't talk to her. I got both of them pregnant at the same. You know what I'm saying? So like,
to be fair to James, Your Honor, what we're not hearing is anything about the substance of those calls, whether he's talking about court or proceedings or anything directly related to Miss VC.
The same time?
Yeah.
Okay. All right.
Yeah.
Go ahead. No. My bad.
Yeah.
I'm sorry, Mr. Bernstein. I didn't mean to interrupt.
I was just saying, Judge, what we're not hearing is the substance of those calls that relate specifically to Miss VC. Anything that would indicate that it is Miss VC herself. We're talking about the number, but as far as like what's on those calls, I mean, what we're not hearing does kind of support what James is saying, that he wasn't calling Miss VC, Your Honor.
Okay. So there's no way without me seeing, I mean, you haven't seen them, Mr. Bernstein, that we're going to know. But my posture on those cases is that if the people are representing to me that the number is the same, I don't know what's going on. Doesn't matter to me.
Judge Simpson is doing something here that experienced judges often do in uncertain situations, making a temporary control decision while leaving the door open to revisit it later. That's why he revokes the phone privileges now, but immediately tells defense counsel that if the recordings support the defendant's story, the court can reconsider. That is actually a very balanced judicial approach. He's not making a final declaration that the defendant lied. He's saying the court has enough concern to act cautiously until the evidence gets reviewed properly. And from a courtroom management standpoint, that protects the integrity of the no-contact order while still preserving the defendant's ability to challenge the allegation later. What also stands out is how calm the judge stays despite the hearing becoming increasingly chaotic. The defendant keeps interrupting because he's worried about contacting family members, children's mothers, and relatives, but Judge Simpson repeatedly redirects everything back to one issue: bond conditions. That's the center of the court's authority here. And then comes another important legal reality check from the judge. He points out that the defendant is already being held elsewhere anyway, meaning changing the bond amount right now may not practically change custody status at all. That completely shifts the strategy discussion.
All I know is that the number is the same. I'm not sure what those conversations are. Mr. Bernstein will listen to it, but this time I'm going to revoke your phone privileges. And certainly, Mr. Bernstein, after you hear the calls, if the court needs to reconsider that, I will entertain that and potentially restore his phone privileges. Okay.
That means is when you revoke my phone privilege, is it to that number or is it to all my family?
I'm sorry?
Because I call my grandmother, my other kids, mothers, and all that. So is it revoking that number?
I get you. I'm just saying that what I'm hearing right now is that you violated a condition of your bond. You're telling me you haven't. I've got this phone number. Your counsel hasn't heard it. So what I'm saying is I am, as an initial position, going to revoke your phone privileges. He'll get the phone messages. He'll be able to get to you. They can get to me. I'm not saying I might not restore them, but at this point, this is what I'm going to do. Okay?
All right.
I'll get on it fast.
Yeah, because I need to talk.
So his phone privileges at this time are revoked. With reference to the bond amount, when is the other hearing
August.
on
It shouldn't.
So, and that's the case that bond's been denied.
Yes.
So, okay,
He's not going anywhere anyway.
Well,
So
I know. I get that. That was going to be my point. I just wanted to check the dates. And so I'm just going to continue his bond as it's currently sat until we can get to the bottom of it, because he's going to have a preliminary examination before that other case comes up. I'll set preliminary examination in person. Thank you.
Your Honor.
Same thing.
And now we transition into an entirely different type of courtroom problem. The previous hearing was about alleged violations and communication issues. This one is about accountability colliding directly with personal life consequences. Aaron Brown's attorney is already preparing the court for bad news by openly acknowledging that jail time is expected. That's important because defense attorneys usually do not concede that reality unless they already know the judge's patience is basically exhausted. The request to self-surrender on Friday is an attempt to soften the landing, to give the defendant time to organize family responsibilities and prepare emotionally before custody begins. But here's the problem. Judges care deeply about compliance history. And Judge Simpson is about to explain that this defendant has allegedly continued violating conditions repeatedly, including issues involving alcohol screening requirements and tether violations. Once a judge believes somebody has ignored multiple opportunities to cooperate voluntarily, flexibility starts disappearing fast. The emotional angle also makes this hearing especially intense because the defendant immediately brings up his daughter and prom. Those are human moments that absolutely matter emotionally, but emotionally compelling arguments do not automatically outweigh repeated compliance concerns in criminal court. And when defendants begin openly resisting timelines in front of the judge, hearings can escalate almost instantly.
Court does call the case, the people of Pittsfield Township versus Aaron Brown.
Silvana Reed, Assistant Public Defender, with and on behalf of Mr. Brown. Mr. Brown, could you please unmute and state your name for the record?
Aaron Brown.
Thank you. Your Honor, we have reviewed probation's recommendation. It is for jail time, and so obviously this is not something that Mr. Brown is looking forward to, but he does understand that is most certainly what the court will order. We would just like to ask, if possible, for him to be allowed to turn himself in on Friday, as he has a bit of time to serve in custody and would like to be able to get his affairs in order.
Is there anything you want to say?
I got prom next month. I've been here 17 years. I'll turn myself in after that. I'm not coming there Friday. I ain't missed a beat with my daughter. I've been here the whole 17 years. I can't turn myself in Friday. I don't want to go against your orders. I wish it could be another way. I'm not running from you. I had this thing on when I come to you. I turn myself in, but it will not be Friday.
Well, tell you what, you can elect to do it your way, or you can elect to do it my way. That's going to be your choice. You decide you don't want to do an alcohol screening and assessment. You don't want to do anything. You continue to violate on the scram tether. So here's what we're going to do. It's a sentence of the court. I'll just order the $125 statutory fees. I will order 93 days in the, hold on a second. Is that the max on this? Yeah. I'll order 93 days. Well, hold on a second. What did he plead to? Operating one. Okay. I'll order 93 days, Washtenaw County Jail. Credit to defendant to serve the balance. Defendant has told me he doesn't want to report, so we're going to do it this way.
I didn't tell you.
You report. I'm going to order that you don't get to choose your time.
I mean, can we work?
I'm going to order that you report to the Washtenaw County Jail by 6 p.m. today. Failure to report there'll be a bench warrant issued for your arrest. That event bench warrant will issue with no bond. So you don't report 6 p.m. today, your choice. I'll send people to get you. It's real easy for me.
This final hearing perfectly captures why courtroom proceedings can turn so dramatic so quickly. Aaron Brown tried appealing to emotion, family responsibility, and personal timing, but Judge Simpson kept pulling the conversation back to one core principle: court orders are not optional negotiations. The biggest turning point came when the defendant essentially tried to set his own surrender schedule. That almost never goes over well with judges, especially after repeated allegations of non-compliance. And you could hear Judge Simpson's patience disappear in real time once he believed the defendant was attempting to dictate the terms instead of following them. The sentence immediately became firmer, more direct, and far less flexible. Legally, the judge laid out the consequences very clearly: report by 6 p.m. or face a no-bond bench warrant. That is the court drawing a hard line. No ambiguity, no misunderstanding. Show up voluntarily or law enforcement will make the decision for you. Across all these hearings today, the common thread was credibility. Whether it involved communication problems, alleged phone violations, or reporting requirements, every outcome came down to whether the judge believed the defendants were fully complying with court expectations. And once credibility weakens in court, everything becomes harder. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.